Good afternoon, everyone, and welcome to our workshop entitled Don't Lose the Farm. We are so happy that you've decided to join us today, and we can't wait to provide you with exclusive information and resources that will give you a deeper understanding of us and our services here. My name is Emily, and I'm the Marketing Director for Clinkscales Elder Law Practice. We have our main office in Hayes, and then we have our other office in Wichita, and we do serve clients and families throughout the state of Kansas. I would like to invite you all to type any questions you may have in the chat box that's located at the bottom of your screen throughout the presentation. And then at the end of the workshop, we will address any of those questions or concerns that you may have. All your questions will be anonymous, so we love having questions come in. Feel free to ask anything that comes to mind. And without any further ado, I'm going to go ahead and hand it over to our attorney and president, Randy Clinkscales, to get us started.
Thank you, Emily, and welcome to this presentation. And I really kind of consider it a workshop because I do appreciate your questions. And so feel free to type in the chat box. Before we get started, Emily, I just want to make sure that everybody's hearing us. I know somebody in the last session had some problems. So if you can hear and see okay, type Y for yes in the chat box, type N for no in the chat box, and we'll wait a few seconds and see what's going on.
Lots of Y's coming through.
Okay. So why the title? Don't lose the farm. I grew, first of all, let me apologize for my voice. I'm a little bit hoarse. That's from yelling at the TV and watching the Chiefs game on Sunday night, but luckily we came out with a victory. But when I grew up in a small town, one of the sayings that I heard very often was "Don't lose the farm" or "Don't bet the farm," and it really didn't have necessarily anything to do with the farm. It just means don't bet everything that's important to you. And so today, what we're really talking about is how not to lose everything that's important to you or something that's very important to you. So today you're going to discover ways to make sure your decisions and wishes are followed. You're going to discover ways to transition your farm, your business, or your property to your family, spouses, or others, protecting it from excess taxes, in-laws, outlaws, and probate court. Also, finally, we're going to talk about how to pay for long-term care without going broke. So is this for you? It is if you do not have an estate plan in place that is current and addresses your goals and concerns. If you're wanting to transition your farm, business, or property and be sure it's protected and gets to the right place. If you're wanting to be sure your spouse is protected. If you're concerned about how to pay for care if you become ill or end up in a nursing home. When I visit with the families, I kind of go through a process about what's going on, what are they concerned about, and kind of my favorite question is, what are your goals? If you could wave a magic wand, what would it be that you would hope that we could accomplish, or that I could help you with? And so these are kind of the common themes. Have peace of mind that you have a plan in place that will guarantee that your wishes will be followed, that you have a plan to transition your farm, business, or property to your family without court costs, without court or excess taxes, and protect your plan from in-laws and outlaws, creditors, and the like, and long-term care costs. And then to develop a strategy to pay for long-term care without having to sell what's important to you and without going broke. Okay, so who is our law practice? We're an elder law firm. We focus on helping families preserve and protect their dignity, their health, finances, and legacy. We practiced throughout Hayes and with offices in Wichita and Kansas. I'm sorry, Wichita and Hayes, and begin in 1983. These are my partners, Jenny Walters and Adam Deese. But I guess let's focus a little bit about who am I? I think that's a little bit important to kind of understand where I'm coming from when I'm meeting with families and where my staff is coming from. I'm an elder care attorney, and my focus for the last 18 years has been on working with families who are wanting to protect assets from long-term care costs and have a plan in place, as well as people with aging and chronic care issues. This is my family. I just like to share this photograph. It's my 3 sons and my wife, my daughter-in-law, and my 2 wonderful grandsons, Alex and Max. But I again, let me give you a little bit of background about why I'm passionate. So I had a general practice of law and did a lot of estate planning and personal injury, and unfortunately even some divorce. But in 2000, through a set of circumstances, my mom died and so forth, I began taking care of my grandmother, and this is a photograph of her. I didn't really know how to do that. I talked to all my estate planning attorney friends that I knew, and we knew how to draw up a plan about what happened when she died, but what happens if she lived a long time? What was it that she was really worried about? So I took care of her at a distance, me being in Hayes, she being in Fort Worth. Eventually, I moved her to Kansas, to Hayes, and for 4 years before she passed away at age 96. But what I really discovered from her was her very, very strong desire to be independent, to maintain her resources, merely to support the lifestyle that she wanted. And she was a very frugal, unassuming woman, very kind, and I was very, very close to her, and so her goals were very important to me. So we actually designed our law practice around that model of as if you're taking care of your mother or your grandmother or your grandfather, whatever it is, someone that is dear and near to you. How would you want them to be treated? And that's how we want to treat our clients, and figure out what they want and what they need and advise them. This is from a family we worked with. Said all the staff our family worked with were caring and competent. Their assistance throughout the long journey of mother's struggles with dementia were very much appreciated. And that's a pretty common theme in our office, working with a family that has dementia and helping them through their process. It's one of the most expensive illnesses that I read the other day. Average 5-year cost is right at $370,000 for taking care of somebody with dementia. Another one here, when my wife got sick and needed the nursing home, I was told I would have to sell my home and my farm. I thought I would go broke. Randy saved my farm for me and my children. This is actually one of my very first cases in the elder care attorney. And it was really, really gratifying to be able to help this family out. They'd been told to sell their farm, and so we were able to show them how not to have to do that. So we can help you protect your farm if you have a plan, and if you help us develop that plan. So and again, please understand, I'm using the farm in a real broad sense. It could be a home, it could be an investment, it could be a farm. It's whatever. There's something that's terribly important to you, then we want to talk about what is it, and who are you trying to help. So what you're going to discover today, that if you don't make a decision the law will make one for you. You can make sure your wishes and goals are followed. And I'll get into that more specifically. There are ways to transition your farm, business, or property without losing it to in-laws, outlaws, creditors, or the government. And there are ways to pay for care without losing everything. So let's jump to the first one. What decisions do you need to make now? And if you don't, the government will. This is always kind of a surprising concept, a surprising issue. Kansas is one of 4 states that does not recognize that a spouse has the right to act for you. And so, as an example, if I do not have a power of attorney and I lose capacity, my wife has no power to make decisions for me. To do that, she would have to go to court and have the court find that I did not have capacity and that someone needed to act in my place. In addition, if I were to die, the law has some funny rules about what happens to my property. And I'm going to give you some examples here. So the law imposes rules about what's going to happen. On the other hand, you have the exclusive right to determine who can act for you and how your property can be handled now and in the future. But you have that right, that exclusive right. And so you can be in control. So let's jump into some examples. And these are some cases that we dealt with. So Mrs. G came to us in her 80s. She had 5 children. She was widowed. She has some dementia and is in the nursing home. When her husband died, his trust became irrevocable. But Mrs. G has a revocable trust. We discovered that there was $400,000 in assets, it's a quarter of ground, that was misdescribed in both trusts. So let me explain that to you. Half the property was in his trust, half the property was in her trust, but they described it improperly. And so the property that they described actually was not, they didn't own that piece of property. And this piece of property was to go to one of the kids. So it was really messed up. So in theory, because of the misdescription, one of the kids was not going to get anything. Luckily, we were able to redo the power of attorney, because without the power of attorney, the court proceedings you would have to have court proceedings to amend an irrevocable trust. And again, that sounds much simpler than it is. You've got to show that the amendment that you're making to the trust is consistent with Mr. G's intent. And then, but to do that, you have to get permission from Mrs. G. And if she didn't have capacity, then the court would have to appoint a conservator and find that it's in her best interest to amend this irrevocable trust. In addition, you would have to be able to amend her revocable trust to get all this straightened out. So our solution in this case was that we were able to set up broad powers of attorneys because she had enough capacity. And I'll tell you, we did it rather quickly. Go back to my, there we go. And so that gave us the power to amend the revocable trust, and it gave us the power to correct and amend the irrevocable trust. The effect was we saved thousands and thousands of dollars. We avoided litigation, and the family's wishes were carried out. So they wrote a nice note to us after we got everything straightened out, and said, "So glad we met with you to correct Mom's power of attorney and to fix her trust. We just wanted Mom and Dad's intent carried out." So, a typographical, more than typographical mistake, but that mistake would really have caused a lot of problems. So this is a family that came to us, the Browns, 72 and 70, and the start off the meeting, which I always appreciate, is that we don't know what we don't know. So they'd been married 42 years. Their assets were kind of a hodgepodge of how it was titled. So some of the farm was in joint tenancy. Some of it was in Mrs. Brown's name. There was some oil working interest in Mr. Brown's name, and there were 3 children. They assumed that if something happened to one of them, the other one would be able to act. So if Mrs. Brown lost capacity, Mr. Brown would be able to do whatever needed to be done. That would not be true for anything that was just in her name. But also, I pointed out to them that if they died, if one of them died, the joint property would go to the survivor, but the other property would have to be probated under what's called intestate law, because there's no will. And 1/2 would go to the spouse and 1/2 would go to the children. And I told the Browns, I've actually had this case happen, and it created a lot of hard feelings because basically Mom lost half the property to her children, and a lot of it was income producing, and we had to go get it back from the children, and some of them were not very happy. Well, their spouses were not very happy about trying to deed back property to Mom. So I also pointed out to them that if one of them lost capacity, a guardianship and conservatorship would be necessary. There'd have to be a finding of incapacity. There would have to be at least one doctor, if not 2 doctors involved. There would have to be at least 3 attorneys involved. And so we really, it wasn't a hard discussion to tell them what they needed to get done. So what did they need to get done? We need to set up powers of attorneys, but I need to know who they want to act for them. Who do they trust? And who's a backup? We talked about the advantages and disadvantages of a revocable trust over a will. And in this case, I'll tell you, we went with a revocable trust. I would have a talk with them about irrevocable trust. Are there properties that they want to pass on to their kids that they know they're not going to sell? Not a right or wrong answer. And my recollection is that in this case, we did put the farm into an irrevocable trust. We could also talk to them about setting up a limited liability company. And I think, in fact, we did, because we want the LLC to be able to operate the farm after they're gone. We looked at their life insurance and to try to determine if also whether they needed long-term care insurance. Right now I'm concerned about valuation. The tax laws are about to change in 2025, and they're going backwards. So right now, you can pass on $12 million tax-free. In 2025, it drops down to between $5 and $6 million. And so we want to talk about, also really key in these kind of plans, is what's the dynamics of the family. So I know I worked on some notes a little bit ago before we started today with the family. There's just a daughter and a son, but the daughter has some real spending problems. And so the family is concerned about how can we address that. and protect that so that she doesn't waste it all and end up with nothing. So what do you need to do if you're wanting to avoid the government from making decisions for you? And that's, you need to have a plan. You need to put something in writing, and we do that with a strategy session to determine what options are available to you. We need to determine what plan you need to have to be sure your wishes are followed. And then we need to start implementing the plan right away to avoid roadblocks or changes in circumstances. I don't have this as an example, but I met with a family several years ago. Between they went home to think about it, in between the time of them going, us having the meeting, them going home and thinking about it, Dad had a stroke. And so he lost capacity. And so a lot of the planning that we were wanting to do, we could not do because he had lost capacity. How do you transition your farm, your business, or assets to your family or others without losing it to in-laws, creditors, or the government? And this is terribly important. So a little bit about, like I told you a while ago, where we've got a son and a daughter, and the daughter's got some spending issues. I have another case. I'm thinking it was last week, where the family had their power of attorney agent was going through a divorce, and so and she was going to be getting a third, I think, of the property. And so what do we need to do to be sure that she doesn't lose it in the divorce? So we talk about what are your concerns? Disabled children, remarriage, in-laws, outlaws, creditors or other problem of the children. We call it the 4 Ds: divorce, death, drugs, and disability. Kind of a hard discussion is dividing property. Equal and equitable are not the same. So as an example, sometimes you may have one child who has been devoted to the farming operation or devoted to mom and dad, and while the others have gone off, and you want that child to be able to continue to farm the property or have the property, whatever it is. And so you may equitably, it's not equitable to be equal in that particular case. Do you want to be able to control what's going on, and do you want to be able to change your mind? These are all discussions that we want to have. And then the other one is, when do you want to transition? Now or at death or in the future? And how's that going to be paid for? How are people going to accomplish what you want to accomplish, whether that's requiring a buyout or whatever? So let's here's a good example. The Augustines came in to see me. They wanted to transition their farm to their children. They had started to sell it. A bunch of red flags went up to me. And so one of the things that Mr. Augustine had told me is that I want to stay in control, but I want to be sure my wife and my land are protected. The red flags I saw were that they were going to pay a whole bunch in capital gains. Those capital gains would be added to their income because their income went up so much. Their Medicare premiums would go up. It would create some tax problems for the kids if they wanted to buy each other out. And they would lose control. And I think that was probably the big deal. If their income goes over a certain amount, they get taxed with another tax called a surtax. And that actually goes into the healthcare industry. So how can we avoid that? In this particular specific case, we set up the Augustine Irrevocable Asset Protection Trust. And what we did is we put their farm into the trust. They actually went ahead and let the children have the income But we allowed Mr. Augustine to determine who was going to farm it. In fact, he was going to continue to farm it for a while. The children will get a step up in basis so that when the Augustines die, as long as their property doesn't exceed the 6 million or the 12 million or whatever the amount is now, there are not going to be any taxes if they try to buy each other out, the kids. There's not going to be a whole bunch of taxes on the capital gains. They retain the right to change beneficiaries. And this is important because they're concerned. The Augustines are, not that old. They're in their 60s. They're one to, so they could be around for a long time, and the kids could go through a lot of stuff. So they want to be able to change the beneficiaries in case there's a change in their dynamics. And so we've avoided the tax consequences and the surtax, and we avoided the increased Medicare premiums, which could go from $170 a month to $578 a month. So it can be a big deal for a lot of families, and that can really be aggravating. And this is another one where the Jacksons came to us. They're 66 and 69. They knew what they wanted to accomplish, and they had a business they wanted to protect, a son that was in that business. They wanted to transition it to him, but they had some interesting family dynamics. So, what we did in this particular case, so let me talk about the family for a moment. They have a son, Bud, who's married with 2 children, and he's the one that works in the business, and he hopes to take it over. They have a son, Mark, who's deceased, which was interesting to me because he was still a pay on death beneficiary in some of their IRAs. But he has a special needs child, and they want something to go to that child. They have a daughter who's going through a divorce and has 1 child. And then their wayward child is Barbara, who's been in and out of drug rehab programs, is divorced and has 2 children who live with their father. So she lost custody. So as I say here, they want the business to stay in the family, but they want to be fair to all the children and avoid litigation. They want something to go to the grandkids. If they do nothing, there's no power of attorney with their wishes. And as I said, they don't have the power to work for each other, to act for each other, and a court proceeding would be necessary. If they both died, there would be a probate. If they both died, children would get everything equally, and the business could be lost. Debbie's share could end up getting lost in the divorce. Because of Barbara's drug issues, the property could be lost. Really important to me is the disabled child of Mark could be disqualified from benefits. And then, so it's just, not a good situation. So our solution in this case was that we set up really good agents with powers in their powers of attorneys. And we added 14 additional powers to the POAs to make them really strong. We really buffed up their healthcare. We made their healthcare power of attorneys really strong, and we talked about what was important to them. So as an example, I have a lot of language in my healthcare power of attorney about dementia and what to do if I have dementia. We set up a revocable trust to manage and avoid probate. We protected the business for Bud and expressed why, so that we can avoid litigation. We protected Debbie's inheritance from the divorce by putting it into her share into a discretionary trust. set up a special needs trust for Mark's child, and we protected Barb's inheritance from her drug problems, again, through a supplemental needs trust. And we set it up so that if she did predecease them, it would be held in a trust for her children, not to be managed by their father. And so then we got all the beneficiary designations straightened out to be sure that this plan went the way that they wanted. And again, they concluded by saying, thanks so much for your help. We didn't know what we didn't know. And then I want to talk about the Stuckeys for a moment. And it seems like about every other week I get something like this. So in this case, the Stuckeys have 5 children, 4 boys and 4 girls and a boy. They have several quarters of ground, some farm equipment and cash resources. Their concern is that if they divide the farm 5 ways, there won't be enough to farm, which is going to cause a liquidation. So let me tell you, and again, I'm telling you what worked for this family under these specific circumstances. So don't go do this without some guidance. We set up an LLC for the farm and appointed Mr. and Mrs. Stuckey as the managers. Upon the death of both of them, the LLC is divided among all 5 children, but we specified that the son is the new manager. The land cannot be sold from the LLC for 5 years, and if sold, the LLC has the option to purchase it at a discounted price. We added some protection, however. We actually put the LLC into a special type of irrevocable trust, and we protected it from the Stuckeys' long-term care cost in the future. So again, this is a very specific case that I'm telling you, but I wanted to show you some creativity that we had in this case. A lot of people think you've got to have a lot of resources to do planning. That's wrong. Sometimes I think we're almost more helpful for people without a lot of resources, because they're the ones that really can really go broke fast, can really lose everything fast if we don't have a plan. So here's a nice comment from a family. We do not have a large estate, but want to make sure that what we have goes to the individuals that we want. Also wanted to have health and financial items in case of hospitalization. Thanks for the great experience, JP. And then another one, I appreciate it. Let me give you some background here. This was a fairly young woman who lost her husband suddenly. And they had resources, but they did not have a plan. And so it was a lot of months of helping her and guiding her to get things straightened out and to get them into her name. And then we set up a plan for her. But when we got done, she's just a great friend of our office. And she says, I appreciate that Randy did the initial interview, getting me started. I was so distraught, still in shock, grief, that I didn't know where to start. That first meeting solidified the entire experience. I can't say enough good things about Nikki, and that's the paralegal in our office that worked with her. What a gem you have there. Everyone I dealt with in the office was fantastic. I felt cared about, my concerns addressed, and basically felt like I had easy access to my lawyer whenever needed. Your practice gave me comforting process during a very difficult time in my life. And then the final one I want to talk to you about, because I do think this is important. I think it's very important that when we go into a meeting with a client that we need to ask questions, but we also need to listen. And I hear a lot about people who are saying that the lawyer didn't listen or didn't explain to what's going on. And I'm not sure I have the right thing. I get a lot of those. I look at a lot of estate plans and where the client says, I don't know if I got what I wanted. So this was a quote from AB and said, we went to another attorney and met several times. He then put together his plan, not ours. You are the first attorney that we feel really listened to us, helps us set our goals, and then follows our decisions. You helped us decide things we didn't even think about, but were important. Those were really nice, and I was really proud of that. I think Adam or Jenny met with this family, but I just thought that spoke really highly of how they met with the client and established that bond and relationship. So what do you need to do if you're concerned about how to transition your property while protecting it? And we've talked about this a couple of times. We need to meet with you to schedule a strategy session. We want to discuss your goals for transitioning your property, and we can give you some ideas. We'll establish who's going to act for you if you can't. And then we want to get in strong powers of attorneys and other estate planning documents so that if something happens to you, we can continue to get your plan put into place. So our last topic today is how to pay for long-term care without going broke. And I will tell you that in crisis cases that we hear that call our office, this is the number one thing. How do I pay for care without going broke? One of the points I'm going to try to make with you is that if we plan in advance, then we're not in a crisis. So the point is you make a decision on how to pay for care, and then how do we do that? But I want you to understand that you don't have to go broke if you need long-term care. And we're going to talk a little bit about how you can use government benefits to pay for care, such as Medicare, VA, and Medicaid. So using plan resources to pay for care. So in this case, we actually got called by the Schmidt's children. And they had just purchased, within a month or two of our meeting, some long-term care insurance. And then the kids were looking it over and became concerned. Number one, it was really expensive. And number two, it really had limited coverage. And so they were really concerned that their parents were buying a pig in a poke kind of a thing. And so we sat down with them, and let me give you a little bit of background. They're 72 and 70, both retired. He's got some money in an IRA, $350,000. She had $200,000. They have investments of $300,000. They have 3 children. A big concern was if one gets sick, they don't want the other spouse to be impoverished, and they would like to leave some money to the grandkids at the end of the day. What we did is there's something called the Pension Protection Act. And so again, let me just kind of explain our role to you with them. Our role with the Schmidts was to help them find a better solution than what they had right now. That solution involved us doing some legal work, but it also involved us getting them in touch with the right tools, maybe tools that we don't have, but tools that we can access through other financial advisors or the like. So in this particular case, we had the Schmidts purchase a $250,000 life insurance policy. And they did that by a one-time payment of $150,000 out of their IRA. So let me tell you why that's important. They were able to buy $250,000 for $150,000 and no tax consequences. Because of the Pension Protection Act, we could roll it over from the IRA to the life insurance policy. But why? Why have another life insurance policy? It's a good question, because this life insurance policy, you can buy a rider that has a long-term care rider. The long-term care rider would pay $7,000 a month for about 5 years, and there's no annual premium. So let's talk about a little bit how it works. If they filed a claim for long-term care, so let's assume they filed a claim and they were in the nursing home for 5 months and they filed a claim for $35,000. And later on passed away. That $35,000 would be deducted from the $250,000. So their family's still going to get something because they haven't used up all of that long-term care insurance or the life insurance policy. Versus my long-term care insurance, which is a traditional long-term care. If I don't use it, I lose it. So again, I'm not criticizing traditional long-term care. I'm just saying for the Schmitz, it worked out for them, and they don't have monthly or annual premiums. And then I want to talk to you a little bit about one that actually was very proactive. The Lundgrens contacted us from a doctor, a neurologist's office, who recommended they get a hold of us because she knew what we did. They have a family farm. Mr. Lundgren is in his early 60s. He was diagnosed with early cognitive decline, but he's still a very active farmer and cattleman. He still has capacity. But he's concerned that what's going to happen if years from now he needs care, and he's concerned for his wife and his children. And when I met with him, it was a very emotional meeting, and he finally said, "I want to stay in control, but I want to be sure my wife and my land are protected." So we set up broad powers of attorneys, and we put his land into a special asset protection trust. We added some care instructions to his healthcare power of attorney and met with his agents so they know his wishes. So the result was that though it may be several years before Mr. Lundgren ever needs health assistance, his goals are achieved through his plan set forth in his documents. His land is protected. He remains in control and remains farming. But we've given his wife power to further protect assets later on if he ever loses capacity. And we've also outlined his care goals and onboarded his family. So it takes a lot of pressure off of him. So that if he gets to the stage where he cannot make healthcare decisions, they know what his wishes are. So I want to wrap up talking about what happens in a crisis case. And we're using Medicaid. And so one of the things I want to point out to you, this is a good example. There is a lot of things you can read, you can hear at the coffee shop, a lot of things you can read on the internet. There's a lot of poor advice. There's a lot of general practicing attorneys that do not understand the complexity of Medicaid. You have people with vested interests in the answer they're giving you. So, what I try to tell people when I meet with them is get all that out of your mind. Just get it out of your mind and let me tell you what the rules are and what we can do. So in this particular case, Mr. Reed has cancer. He's moved to a nursing home. He's paying $8,000 a month. He's married. Their asset includes Mrs. Reed's $80,000 IRA, a home sitting on a quarter of ground, and a joint account of $60,000. they were told, Mrs. Reed was told by the nursing home, she would need to spend down all the resources before Medicaid would help. And Medicaid would put a lien on the home sitting on the quarter of ground. They encouraged her to sell the quarter and just keep the home. She was worried that her husband would not get good care if he went on Medicaid. So our solution actually was to tell Mrs. Reed, ignore everything that you've heard. Let's get Mr. Reed on Medicaid. And we showed her, we did that for her. We set it up so that Mrs. Reed kept all of the assets. Medicaid cannot put a lien on her home or the quarter. She gets all the income from the quarter. If Mr. Reed, and so we actually then began working with her to be sure that he was getting good care at the facility. I want to add to you, tell you that if Mr. Reed had been a wartime veteran, VA benefits would have been available in this particular case. And so, I've got a new client right now that is living at home with her daughter. Everything's going really well, but I can see at some point they're going to need some assistance in the home. And actually, we're going to be able to tap into VA. She's a widow of a veteran, a World War II veteran, matter of fact. And so she's old, but the VA will pay her up to $1,200 a month to help pay for that assistance. So, I always want to explore that. If we have a wartime veteran, there's a bunch of rules about that. This is a nice one that my father, Henry, and I met with this firm and decided to hire them. Best decisions of our life. They had great knowledge and helped us apply for funds that we had no clue were available. They are there anytime you need them and return calls quickly with answers. Over the years, I've even became friends with a few of the staff. Great team to work with. So let me just kind of share with you a little bit of what happened in this case. We were able to tap into other benefits without having to go on Medicaid. So I think that they really appreciated not having to go to that next step, but also really appreciated being able to stay at home. So what do you need to do if you're concerned about how to pay for care? And again, we would like to meet with you and explore all funding resources, just like the last family. Get in place strong powers of attorneys and other estate planning documents, and plan about how are we going to pay for care. And our goal is to get and pay for good care without going broke. And that's kind of our mantra in our office. This is a farmer I worked with, and I think I always appreciated it because it was very, very hard for him to come in to see us. It's very, very hard for him to admit that he needed some guidance or assistance. But he was trying to take care of his wife, who was really, he just could not leave her. And so we helped him through a very difficult time. And when at the end, he wrote a nice note to me and said, I felt very comfortable with everyone I worked with. Clinkscales helped us through some very hard years. So far, you've discovered there are ways to make sure your wishes and decisions are followed without interference from the government. You can decide how and when and to whom your property will be transitioned so that you protect your family, your wishes, and your property, and reduce or eliminate government control and taxes. And there are ways to plan for possible long-term care costs, and the plan will protect your family, your spouse, and your assets. I think today we need to really understand that the possibility of needing some outside assistance
is much more real a reality than it used to be. So I hope that you get this one thing. You can decide, or the government will decide for you. Planning with an expert with us improves the opportunity to preserve your wishes to save the farm. We do this every day. It's not part-time. It's what our focus is. So how do you make this happen? We want to talk about different strategies that are available and then make recommendations to you. We want to talk to you about ways that to transition your farm, your business, or your property to your family or employees, either now or at death or in the future. And we want to talk about planning strategies to pay for care without losing anything. So how does this work? So let me just share with you a little bit. I think sometimes people say, my problem is too little to talk with you about. I met with a family the other day that thought their problem was too little and too simple. It actually was quite complex. And in fact, it was kind of a challenge to work through what all they wanted to get done. But we were able to do that. So what we do is we have you call our office, and our intake person will visit with you about what's going on. If you and she feels like we can possibly help you, then we will schedule a 60 to 90-minute meeting with one of our attorneys. It can be in person, by Zoom, or by telephone. And at that meeting, we'll review what is your current plan. We'll talk about what happens if you do nothing. I want to talk to you about what your goals are. Again, that wave the magic wand. Determine what's important to you to protect. And then we'll talk about maybe some ways that we can protect your property from outside forces. And then I'll answer the questions about your unique situation. And please believe me, everybody has a unique situation. They just do. I think that's what I enjoy about this job, is that everybody is different, everybody's special, everybody has their own story. At the end of our time together, I'll have an analysis of your current plan. I'll understand with better clarity what your issues and goals are, and you'll know that. Then we'll talk about a blueprint to achieve the goals. And then based on all that information, and we're going to have you bring in a bunch of documents and stuff so that we can look at it, but we'll give you an exact amount of the investment to achieve those goals. So here's the most important step. Decide to get started. And not to decide is to decide. And so once you decide to get started, we'll actually schedule a next meeting to iron out the planning details if we didn't get to that. Then we'll draft a plan and the necessary documents to be signed. But that's only part of it. Then the next part, and we call it funding, is to get everything lined up the way, all the property lined up the way that corresponds with the plan and the documents that we've prepared. And that takes a little bit of time. But we want to ensure that your plan is complete at the end of the day. So typically for just a strategy session like this, it's $450, but because you've attended today, it's free. Sounds too good to be true. What's the catch? We've scheduled 8 spots in the next 4 weeks, and I can tell you 3 got taken already. And so if you want to book your strategy session, call this number on the screen. And Emily is also going to send you a survey monkey that you can click on there. Either way will work. And again, what's that going to do? That's going to prompt us to have a have you talk with an intake person, just a few minutes, 5 to 15 minutes, according to what's going on. Make sure we can help you, and then she will then get you on one of our attorneys' calendars. So my personal guarantee, if you have a strategy session with my office, is at the end, you're going to know more than you did today. You'll have an analysis of what happens if you do nothing, and your time's not going to be wasted. So if you want to schedule a strategy session, call this number on the screen or click on the Survey Monkey that Emily is going to send out. And if you do, you're going to get this book, Protect Your Family, Don't Write a Blank Check to the Nursing Home. And actually, I was a co-author of it. You'll have a written summary of our recommendations. And again, free strategy, an analysis of your current plan, free written report to achieve your goals, and the free book. So call the number on the screen or click on the Survey Monkey. So I am now going to turn it over to Emily and see if she has any questions that we need to talk about.
We did have a few questions come through, but I do want to encourage everyone to go ahead and use this time to type them in the chat box if you have any questions as well. Our first question, Randy, and you covered this a little bit, but our mother will need to go to the nursing home sooner than we thought, but we are not prepared since we've been putting it off longer than we should. Can you help us with Medicaid and potential veterans benefits from her late husband in order to help offset and pay for this cost?
Yes, to answer your question, we're VA accredited, and we have a team of three that actually does nothing but Medicaid. But we like to explore what are the other possibilities out there. Again, I don't know where your mom is in terms of transitioning, whether there might be a less restrictive environment, but that's just a conversation that we would have with you. And does she have capacity, and what can we get something signed like a power of attorney? But yes, that's something that we deal with weekly at least. Thank you for asking that question.
Yeah, that was a great question. We do have another one that you also touched on a little bit, but just to reiterate, our family has some documents in place that were created about 13 years ago. A lot has obviously happened since then. Can we come into your office to update and make sure we have everything done that we need, or things that we didn't know that we needed?
Yes, and so I'll make a true confession to you. I drafted my documents in 2008, and there's a rule of law that an attorney who represents himself has a fool for a client. So I took my documents and I gave them to my partner, Jenny, and asked her to review my documents. And so as a result of that, we made some changes a couple of years ago. So certainly documents that are 13 years old are going to need to be updated. The powers of attorneys, there have been a lot of changes in that time period in power of attorney laws that I probably change my power of attorney every couple of years, just because of the changes in the laws, as well as the changes in my family dynamics and what I want to accomplish. But yeah, that's a very common, we would have you bring them in, and we would visit with you and talk about what you think happens is under your estate plan. Sometimes what people think is going to happen is different than what actually is the documents say. So we want to be sure that the purpose of the documents is fulfilling your wishes.
Perfect. Those are great questions. Thank you for asking. It doesn't look like we have any additional questions in the chat box at this moment, but please do feel free to add those questions now as we wrap up our presentation for this afternoon. I do want to kindly remind everyone that you will receive that follow-up email that Randy mentioned that will contain the important items. The email will include a recording of the session, and we provide that to you so you can share it with other family members, friends, coworkers that weren't able to make the session today, or just so you can go back through and take notes on all of the important topics, since Randy covered a lot in a very short period of time. The other thing that email contains is a SurveyMonkey link, and I did put that in the chat box already for you to complete. Like Randy mentioned, we already had 3 people claim from this morning, so we really don't have a lot of time before the end of the year. So please get with us if you have any questions. If you do fill out that survey, you'll receive the completely free strategy session where you will speak with one of our attorneys about your completely unique situation. Also, go ahead and call that number on the screen if you have any questions regarding the sessions. If you have any questions regarding your situations, just feel free to give us a call and we'll be very happy to help you if we can. And I would also invite you to stay up to date on our upcoming events on our website. We will be having an in-person dementia-focused workshop Thursday, December 1st in Hayes at the library. And then afterwards, we will have a small reception with snacks and drinks at our office where our staff will be available to talk with you and answer questions. And so you can just kind of get to know us more. And that information is on our website at clinkscaleslaw.com. Or if you have any additional questions about that, you can call us, email us, and we can get you registered and RSVP'd for that event. I don't really know if we can answer this question. It's a great question and we get it a lot. But Randy, would you be able to give an idea of costs beyond the initial consultations for POAs, wills, etc.? It does depend on everyone's situation, so it's kind of a hard question.
Yeah, but I think it's a fair question. You know, I think it as Emily said, it can vary greatly. I know just like a simple estate plan is probably going to run in the neighborhood of $2,800 thereabouts. It could be, but it could be, you know, quite a bit higher based on the complexity and what's going on. But a lot of people, that's good enough. But again, there's no obligation if you come in for the free consultation. So don't feel like you're bound by anything. And again, sometimes we find that someone may just need a little tweaking of a power of attorney, or maybe it may be that we just need to assure them that everything that they have is correct, and then there may not be any charge at all for that.
Great question. Thank you for addressing that, Randy. We do have another question.
Okay.
What if an elder lives in Kansas and some of their children live in other states? Can you still help?
Well, I hope so. Yeah, that, you know, that's a very common. That's very common, and so a lot of times we're actually the eyes and ears for the family in Kansas, and so you know, I'm one of those. You know, my kids, two of my 3 kids live out of state, and so you know, I would hope that someone could help me when I transition to that point. But no, that's very common. And again, probably, you know, I would guess, I wouldn't be surprised if 25% to 40% to 40% of our clients are you know, don't have family around. We even have some people that don't have any family, and so we help them and look after them and provide the support services for those families. And that's a tough situation, but a lot of times we can tap into some of their friends and churches and things like that to set up a good support system for them. So, and that's actually a really good question, and I really appreciate that caring question. So.
Yes, great questions. If anyone thinks of any later, please feel free to contact us. Thank you so much for your time this afternoon. Randy, thank you for sharing the information, and we look forward to hearing back from everyone soon.
Thank you, everyone. Thank you, Emily.